Hi, everybody. This is Jeff Fowler with the Apartment Owners Association, and it is great to be with you today on a Friday. I know we don't normally do Fridays, but here we are live on Zoom and on YouTube, X, Facebook, and we just started to become more active on X, and just especially politically, just talking about the ills of rent control and how it really does destroy the housing stock, discourage investment, and really increase the price of rents for people when they move into a new place. They have to supplement or subsidize the artificially low rents that you're giving for someone who's living under your rent controlled unit. So anyway, we're really hitting that hard, and we would love for you to join the fight with us on that. So search for us on X, AOA USA, just like the YouTube channel, AOA USA. Give us a follow. And like when I post, I'll mention city council members, and I think that's a great way for them. Hopefully, they'll take a look and just kind of understand how destructive it is. And anyway, we're going to talk about how to collect rent debt today. And so this is it's really a big deal to be reporting your debtors and sending them to collections so that it goes on their credit report. And also, hopefully, you'll get some money back. And it's tough to get money back from someone who doesn't have any money, but there's times when you can get that back, or within a few years, maybe they're in a better place for it. So we're going to talk about that. And before we get into that, I do want to mention, just because it really is an issue in many of the counties, whether it's Orange County, LA County, um, Sacramento, just all throughout the state, there are multiple counties now where they've redacted some of the information from the criminal files. So an instant criminal search, like you may have noticed, we changed the name of ours from instant to quick. And it is a quick search. It's hitting a database. We're using the best one that's out there, and they actually look at arrest data because the data in the criminal file is just not there for them to say positively that your applicant, John Doe, is the John Doe in this criminal file. And so it's very sophisticated. The way that they do that, it's best thing that's out there. So you get that when you're using AOA tenant screening, but the only problem is that that's if there's an arrest record, and there's not always an arrest with a conviction. And also, a criminal report is exactly and only that. A criminal report is not a civil, it's not a civil search. So if they are litigious, if they've been convicted of domestic violence, things that actually matter, they're not in the criminal, but they're in the civil file, we really think that you should perform a civil search as well. And not just you do a civil search, and lots of times you just are getting the eviction record, but in the civil, besides the eviction, there's other stuff that does matter. We call it the duty of care doctrine. And so you have a responsibility. People will use that against you. If you bring in bad tenants that harm other tenants, they may sue you, and that would be one of the things, duty of care. So we have a civil and criminal investigative search, and I just want to tell you about it one more time, just because it's so important. And once you get a bad tenant in, you know how it works. It's literally thousands of dollars later, headache, and thousands of dollars, maybe an underestimate there, but um, more like it could be tens of thousands. And so spending a little extra to do that is really a no-brainer. You got to get the best people in for the sake of your renters, for them to be safe, but also it's your investment. So I want to really encourage that one, the civil and criminal investigative search. And anyway, man, we've had a couple seminars up in Northern California and Santa Clara and in Fremont. And so I heard that those went really well in Sherman Oaks and San Diego yesterday. So there's been a lot of in-person stuff, and that wraps it up with the in-person stuff for us this year. And anyway, as a member, you get that. That's just part of it's included in your membership. And anyway, I hope I know that the people that went really were benefited from it, and we could talk in depth about a lot of different things and more hitting the political how you can take action politically. And our next in-person event will be the AOA Political Action Committee Luncheon. It's going to be at the Torrance Marriott, and we'll have District Attorney Nathan Hockman speaking for a little bit. I'll speak a little bit, and we'll just connect and network. We're really looking to um, put people together in the district that they're in and create a regular rhythm of visiting your council member wherever you might be. And with those face-to-face meetings, not on Zoom, but really getting face-to-face meetings with city council members and sharing your story so they understand exactly what owners are going through. And we know that as we do that and as we're consistent with it, we know that it's going to make a difference. Not everyone, if it's a Democrat socialist, um, that's a city council member, they're really probably not going to care, but we still can show up there. But there's several there, whether it's LA City or wherever it may be, there's people that are not Democrat socialists that will be willing to listen to why rent control is destroying housing and how um, keeping things the way they are or even moving rent control off could help lower the cost of housing. And we've seen it in Argentina, even recently, where they removed rent control, and lo and behold, the price of rentals went down. And why was that? Because people who were holding their units back were able to rent at the price that they wanted to get. They felt safer. They rented those places out, and as more supply hit the market, and things recalibrated. And anyway, so hope that you can make that packed luncheon, go to the Eventbrite, and you can sign up for that. And before we run out of spaces on that one, would be great to see you there. Get a lunch together, a quick couple hours that we could spend together there. And so hopefully you can make that. And on the like all of these videos, they're being recorded. They're on YouTube. Some of you may be watching from AOAUSA.com. And you can catch all of these on YouTube after the fact, and it's the AOA USA. That's the name of the channel, just like the website is AOAUSA.com. And anyway, so we're gonna we're gonna learn a little bit from Dennis Block here. Before we do, there is that blue help button where you can put questions in, but really this is a Zoom meeting. We have people in on the Zoom, and we're going to answer those questions first, and they electronically will be able to raise their hand, but just hold off on raising your hand until we actually the get through the entire seminar, and then we can take questions at the end. And anyway, our speaker today has done over 300,000 evictions, over 45 years of experience, 28 attorneys on his staff, and he writes the legal Q&A for the folks in LA and Orange County. And he's the founder and president of the law offices of Dennis P. Block and Associates. And so, Dennis, it's great to have you with us today, and I'll let you take over.
Well, thank you very much, Jeff. As always, I appreciate the fact that you allow these seminars to be conducted, and obviously, it's such a invaluable resource for your members. As we know, the law is changing minute to minute, and it is imperative for income property owners to stay up on these new developments because that's where you're number one going to lose income, and number two, find yourself embroiled in lawsuits. So I did want to talk. We are talking today on collecting on your deadbeat tenants, but I did want to open it up for a new development that just occurred this last week that I've been getting a ton of questions on. I actually did a YouTube video on my channel, which is Evict 123. But this deals with the new development by the City Council of Los Angeles, where for RSO properties, they have now limited rent increases. If you thought it was bad before, my friends, it's even worse now. In the past, you were entitled to a rent increase anywhere from 3 to 8% based on the CPI, the Consumer Price Index. Well, the city council has now passed a limitation on that. And what that states is if you do have RSO properties, and while the law is not in effect just at this moment, because the city attorney has to write it, it's already been approved, then it'll be then put in front of the city council for final approval, and then finally the mayor will sign it, which of course they will. So what is this new limitation on your rent increase notices? And that is right now, you're only going to be entitled to 90% of the consumer price index, only 90%. So if in fact, for example, this year in Los Angeles County and also in Orange County, but we're talking about Los Angeles City under RSO, CPI is 3%. So if you're going to have 90% of that figure, 3%, you're down to only a 2.7% rent increase. 2.7% rent increase. And this is on the backdrop that after COVID, we could not raise the rent literally for 4 years. And since that time period, we've seen tremendous escalation in terms of our property taxes, our maintenance costs, insurance costs, which are through the roof. And now we can't even get a decent return on our investments. So just think about that, that the most you're going to be able to get is only 90% of what the CPI is. And again, this year, what you're going to be able to get come soon as it's signed will be 2.7%. But you don't think it could get worse, do you? Well, it can. If you are one of the homeowners or apartment house owners with an older building, which was not individually metered in the past under LA rent control for RSO buildings, you were entitled to add in an additional 1% for each utility supplied. So if you supplied natural gas and also electricity, you would be able to get an additional 2%. Well, that in the new ordinance is wiped out. You can't get any extra money, even though you're paying for the utilities and even though the price of utilities are going up. So this literally is a death blow to landlords in terms of owning property in the city of Los Angeles under RSO. There's just no incentive and there's no way to get a reasonable return on your investment. But unfortunately, this is what we're faced with now. The other law that I wanted to talk about, which is going to come effective as of January 1st, which, let's see, will this law put more money in your pocket or will it put less money in your pocket? And the answer to that is less money in your pocket. Because under this new law, which becomes effective under January 1st, 2026, and this law, by the way, is a state law. So any residential unit in the state of California must comply with this law. And what is this law? It states that you have to supply a refrigerator and a stove for your units. So you can't have it optional. A lot of landlords, of course, have stoves in the unit, but sometimes landlords will say that the tenant has to get their own refrigerator. Well, that's out the window now. Upon any lease that's entered into as of January 1st, 2026, or if you renew an existing lease, so this is not for older units where the tenancy has already existed, but as of January 1st, any new tenancy or any renewed tenancy where you sign a new rental agreement with an existing tenant, you're now going to have to supply a refrigerator and you're going to have to supply a stove. And guess what? When those appliances break down, guess who's going to be responsible for taking care of the cost of the repair or the cost of replacement? And you guessed it, that's going to be the income property owner, the landlord. By the way, you do have to supply them with a standard refrigerator size unless you're in an efficiency apartment. So again, it's just another raping of income property owners where money is coming out of our pockets, but yet we have no way of recouping those. It's insane that of all the industries that exist in the United States, and how many are there? Thousands of different industries. There's only one industry that is regulated by price controls. Only one industry, and that would be our industry. And yet we're affording the public such a valuable commodity in that we're providing housing services for these people, an incredibly valuable commodity, but yet we're singled out. And you can't say, well, people need places to live in. Well, that's true, but people also need baby formula and they also need medical drugs, and those have no price controls. Okay, so that's the two kind of hot topics of the day dealing with the RSO and the limitation on rent increases, and also the fact that, get ready to go to Best Buys to get yourself a refrigerator and stove because it's going to be your responsibility. That's now considered to be that the unit is uninhabitable, believe it or not, if you don't supply a stove or a refrigerator. Okay, let's move on to the opening topic of the day, and that is collecting on your deadbeat tenants. By the way, if a tenant runs off and owes you money, you can give that information to the Apartment Owners Association. They will keep a record, and it does, even if you're not planning on getting a judgment against your tenant, it will at least assist in letting other landlords know that this person was a deadbeat tenant. And also, it might encourage the deadbeat to pay on his bill. But other than that methodology of reporting a bad debt to the Apartment Owners Association, if you're going to collect against these deadbeat tenants, the first thing you need is a judgment. You have to have a judgment for the amount of money. Obviously, if the tenant is willing to pay you, he would have paid you. So, if you're going to be collecting, you need to have a judgment. That's a formal document issued by a court of law, which states that uh, Mr. Tenant owes Mr. Landlord X amount of dollars. Now, how do you get a judgment? Well, if you're filing an unlawful detainer action to evict your tenant, as part of that process, not only do you get a judgment for possession, but you also get a judgment for the amount of rent owed, plus court costs, plus attorney's fees. A lot of landlords, once they get possession, decide that they don't want to get a monetary judgment, and that's just a business decision. But every unlawful detainer does two things. It gets you possession of the premises if you're successful, but it also gets you a monetary judgment. That is that piece of paper stating that the tenant owes you X amount of dollars. So you do want to follow through in most cases that once the tenant vacates, you still want to follow through to get a monetary judgment, and any firm such as mine that is doing unlawful detainers can follow through. But what if, for example, the tenant owes you 3, 4 months worth of rent, and then the tenant just skips out? So that's not an unlawful detainer. An unlawful detainer, as you know, is when the tenant is unlawfully detaining the premises. But if the guy leaves, he owes you the money. Well, yeah, we can report it to the AOA, but what else can we do? And that is you can sue them in small claims court. That's a pretty reasonable method of doing that because the cost on that is very nominal, about $75, $80. You can do it online by filing a small claims court action. Or if you can't do it online, then you actually can go to the court closest to where the property is located. You go to the small claims court office, and guess what? The court clerk will actually fill out the paperwork for you. Okay, so that's the first thing that you can do. Now, there is a jurisdictional limit, and the jurisdictional limit is $12,500. $12,500 that you can ask for in small claims court. If you're an entity like an LLC, then the maximum is $6,500. And also, you can only file two small claim court cases per year, which ask for that kind of money. If you're filing the third case, then regardless of whether you're an entity or an individual that owns the property that you're seeking this rent on, it would be $2,500 thereafter. So once again, the jurisdictional limit is 12,500 if you're an individual, or $6,500 if you are an entity like a corporation or an LLC. Now, here's the problem. Let's pretend the tenant, you're an individual, and let's pretend the tenant owes you $16,000. So you're above the jurisdictional limit. So you're saying to yourself, well, I can't really file a small claims court case because I'm only going to be entitled to 12,500. So what are your other options? Well, your other options would be to file a civil lawsuit. But the problem with that is generally you're not going to have the ability to file a civil lawsuit. It's easy to file a small claims court because it's very informal and they don't allow attorneys in small claims court. But to file a civil lawsuit is somewhat difficult, which means you're going to have to hire the services of an attorney. Well, here's the issue is that most attorneys are not going to want to touch this. They're not going to want to do it on a contingency basis if you don't have a judgment. And attorneys such as my firm are going to charge at least $4,500 retainer and charge you at an hourly rate of $450, $500 an hour. So it just doesn't make economic sense. If you're suing somebody for $100,000, well, then it makes sense, especially if there's an attorney fee provision where you can also get a judgment for the amount of attorney's fees as well. But in the example that I gave, that if a tenant owes you $16,500, maybe the best thing to do is to sue in small claims court and limit it to the 12,500 because quite frankly, it's better than paying a law firm such as mine a fee as what we would require and most all law firms would require in order to file a civil lawsuit. By the way, when we're filing a civil lawsuit, there's no difference in what we're doing if you're seeking $4 million or if you're seeking 16,500, we're going to be doing the same thing, the same amount of work. So let your conscience be your guide that if the tenant owes more than 12,500 or more than $6,500 if you're an entity, you might want to consider waiving that so that you can get into small claims court. But let's pretend that the amount that's owed let's pretend that the rent was $6,000 a month and the tenant owes you, 10 months worth of rent, that's $60,000. Then you do want to file a civil lawsuit. You want to, if you have the ability to do it yourself, which is pretty small odds that you would, then you can do it yourself. Otherwise, you are going to need to engage the services of a law firm. And again, then you're looking at, in generally speaking, an hourly charge. Okay, but whether you're filing a civil lawsuit or whether you're filing a small claims court lawsuit, you've got another issue. And so what's that? Well, when you file a small claims court lawsuit or you file a civil lawsuit, the next thing you have to do is you have to serve your tenant. And of course, the tenant is not living in your place anymore because they moved, right? In an unlawful detainer, they're living there. So when we get the judgment for possession, the judgment for money, there's no problem in terms of serving them because they're living in your property. But if they skip out in the middle of the night, then what? Well, you have to serve them. Well, how do you serve them if you don't know where they are? Well, if you know where they work, you can also serve them there. But if you don't know where they work, then you have a problem. You're going to have to do skip tracing to find out where they moved to. Generally, it's not it's not a good idea to start filing the small claims court lawsuit immediately. You want to wait until that they get out of the property, and once they get out of the property, for about 6 months, they will establish credit elsewhere, and it will be easier for skip tracing to find them and to locate them. I know we have a service at our law firm that if you have used us for any case ever, then if you call us up at no charge, if you call us up and tell us the address where your tenant moved to, or even what their cell phone number is or an email address, we generally, after 6 months, after they've arranged credit at a different location, we can then find them so that you can serve them in a small claims court action or possibly even a civil action. But again, there's no point in filing a civil lawsuit or a small claims court lawsuit unless you know where your tenant is to serve them with the lawsuit. Okay, so let's pretend you did serve them. You got a judgment either in a civil lawsuit or in an unlawful detainer, a monetary judgment, or in small claims court. So, how good are judgments for? Well, judgments are good for 10 years, and under the new rules, can be renewed for an additional 5 years. So, a lot of times when you get a judgment against a tenant, they've got nothing. But sometime down the road, they'll have money maybe in 2 years, 3 years. We find out in our collection cases, and our firm obviously does a slew of collection cases. We have a collection department here with probably the best research tools that exist on the planet. But judgments are good for 10 years, and we find out that in many instances, while we can't find anything in the first year or the second year or the third year, you know what? In the fourth year, the fifth year, we find these assets. And even though judgments are good for 10 years, we can renew them for an additional 5 years. And we do that at the end of the 10-year period or prior to the end of the 10-year period. We'll renew it for an additional 5 years. And the surprise on our clients' faces when we collect on a judgment that's 8 years old and we're sending, the client a check for, $12,000, $13,000, and they're looking like they just won the lottery. But the reality is that you have to be diligent with these judgments and you have to check them on a yearly basis. So don't be discouraged that you don't find money in the first year or the second year. You just have to keep checking on a yearly basis, and that's of course what our firm does. And again, it's good for 10 years, and then we can renew it prior to the 10 years for an additional 5 years. So you know what? In 15 years, I mean, unless the guy dies or moves to another state and you can't locate them, then that's probably going to be a judgment that you can't collect on. Now, judgments bear interest, and the interest rate is 10% per annum, unless, of course, the courts now have made this less. The courts now have, or the state legislature has now reduced it to 5% if the judgment was entered in 2023 or thereafter, 2023 or thereafter. So, consider the fact that each year, if it's $1,000 each year, that judgment at least is gaining for old judgments 10% per annum, or after 2023 gaining for 5% thereafter. Okay, let's move on to the fact of collecting on your judgment. How do you collect on your judgment? Well, when you get a judgment, it's very simple. You call the tenant, you say, hey, pay me. But it usually doesn't work. They're not going to pay you. So therefore, what you're going to need to do is going to have to collect on your judgment. Okay, you have to collect on your judgment. Let's see if I can get this up here. And so what's the process of collecting on the judgment? Well, first of all, you're going to need to locate assets. So what are the assets that you need to locate? And that would be employment. That's a good one if you want to garnish their wages. The second thing is you want to find bank accounts, and also you want to potentially put liens on any real estate that they own. And we do have cases where they do have real estate that they own, and we'll put a lien on that. It's actually very simple to put a lien on property. But those are the basis upon which you're going to want to attach assets. You need to locate these assets, and that is their places of employment, bank accounts, and real estate. And a lot of times after we obtain a judgment, the clients will call us and say, hey, I just found out that, Mr. Smith is now living on Crescent Heights off of Wilshire Boulevard. Well, that doesn't help me. I really don't care after I have a judgment where the tenant is living. I want to know where the tenant is banking. I want to know where the tenant is working, and I want to know if the tenant owns any real estate, because those are the best basis of finding assets. So how do you find those assets? Well, as a collection agency, as we are, where we have obviously all these data reports that we can do, we can actually locate your tenants, for example, your social security, uh, their social security number by either knowing the property address where they moved from, a cell phone number, we can get that. Obviously, if the landlord had an application on this tenant, then he would have known the social security number because we do need the social security number in order to locate assets. But we can find that social security number pretty simple, even if we have the email address of the tenant, or as I stated, the cell phone number of the tenant, or even the property address that he moved from, your property. If he moved from there, we can figure out what his social is from that. So what do we do with the social now that I've got a social number? Well, we then at that point, we run credit reports, okay? And in those credit reports, believe it or not, and we have different ones that we run, but we can find open bank accounts. However, when we find a bank account, and let's pretend we found one at Bank of America and Chase and Wells Fargo. So we'll run what they call a bank levy for that. But unfortunately, while it's a valid bank account, we never know how much is in the bank account, and we can't call up and ask the bank to see that. So we'll run these. And once we do run these, then uh, we'll be able to see what was in the account. Jeff, can you hear me okay? Okay. And
Yeah, I
so
can
that's
hear
one thing
you.
that we can do.
Yeah, I
Okay,
can hear you.
fine.
Yep.
Perfect. Thank you. The next thing we can do by running their social is that we can find their places of employment. We can find their places of employment. And by doing so, obviously, we can then do a wage garnishment. However, that pesky state legislature limits what we can ask for. So now I want to share my screen. And there we go. If it'll let me. Okay, I think it's doing it now. Okay, so it's kind of a chart that I have here. Let me make it a little bit bigger for you. You don't have to worry about any other columns here, but if the tenant is paid on a monthly basis, then you're limited to 20% if the tenant, you can get 20% of his paycheck, okay? Now, actually, I take that back. He has to earn more than 33.28, and then you can get 20% of his paycheck. The problem is that these people, believe it or not, what they do is that they'll work at one place for $3,000 a month, and then they'll leave and work at another place. So they're holding down two jobs, each at $3,000 each, so you can never collect on them. And that's just the status of the way we work in terms of the state legislature. If in fact they're earning more than that, then there's a formula that you can get 40% if they're earning above the 33.28%. And then if they're earning a total of 66.56, then it's 20% of their disposable income, that would be the income that they get after their deductions for their payroll taxes. So even if we have a wage garnishment, a lot of times what we'll get is maybe $175 per pay period. So it's not like you're going to get a lot of money, but at least unless they're going to quit their jobs and go someplace else, and then we'll chase them to a new job, there's a limitation on how much you can get if you're garnishing somebody's wages. Obviously, it's much better if you can find $10,000 in a bank account because then you can grab that money out of that bank account. But otherwise, you're going to get a stream of checks month to month to month, which our clients get. And generally, it's for relatively a small amount, it can be anywhere from $40, up to, 15, 2,000, $3,000, depending on how much they work. There's also an organization called the Work Number, where if you give them the Social Security number, they'll tell you actually where they're working. So Um, these are the methodologies that we use in terms of finding assets once we have a judgment. So once we have a judgment, this is what we have in terms of finding assets. Okay, moving on. Once I have a judgment and once I find the asset, then what do we do? Well, the next thing we do is we have to get from the court something called a writ of execution for money. It's a document that will then order the sheriff to collect on these assets that we obtained. If we're doing an eviction case, for example, we get a writ of execution for possession, and that's going to then tell the sheriff, hey, put our client in possession of the premises, or in other words, let's escort that tenant off the property. Okay. Now, uh, if we're dealing with money, we're going to get a writ of execution for money. So, what are those writs used for? Well, we'll instruct the sheriff to garnish wages, and we have to give them the place of employment. And then that'll be served on the employer's accounting department. And then every time the tenant gets a check, and that's even happened in my law office where a certain staff member was having their wages garnished, and that means that the employer has to pay the garnishment first, and then the balance will go to the employee. The other thing that we do with that writ of execution for money is if we've located money in a bank account, then what we would do is we would then instruct the sheriff with that writ of execution to go over to the Bank of America and to seize everything that's in that account. We can actually also seize stuff if they have a safety deposit box, and we've done this in rare cases, but we've seized contents in a safety deposit box, and sometimes there's cash in there. Okay. Also, the other thing we can do is if we locate property owned, or we think that the tenant does have sufficient wherewithal, we'll file something called an abstract of judgment. If we have an abstract of judgment, what that means is any property that the tenant owns anywhere in the county upon which we got that abstract, or filed it with the county recording office, then this will attach as a lien. We don't have to do anything. It'll attach automatically every single property that this tenant owns, or any single property that the tenant could own. Okay. Also, by filing this abstract of judgment, it also clues in all these credit institutions that there is a judgment against this tenant's name, and it would make it difficult for the tenant even to get a car loan. So on that basis, when we see that the tenant does have wherewithal, we will file this abstract of judgment. It's another document that we obtain from the court within the lawsuit that the judgment was obtained, and then we filed that with the county recording office. So it's a proper filing with that. Now, so those are the basis upon which our firm and all other collection cases do collect on these judgments that are obtained. You know, a judgment's a piece of paper. And while it's good for 10 years, until you do something with it, you might as well frame it because it doesn't get you any money. What you want is money in your hand. So to get that, once again, you've got to locate assets. And once you locate assets, then you're either going to file an abstract of judgment to attach any real property that they own or could own in the future, or you want to get a writ of execution for money and then attach bank accounts or do what they call a wage garnishment. Now, a lot of times when we start running these wage garnishments, we do get issues where the tenant will call us, and sometimes it's, from 5 years ago, so they don't even know what's happening to them. But they'll work into a settlement with us, and we will then either cancel the wage garnishment on the basis that you're going to pay us X amount of dollars per month. And usually it's better to do that as a settlement with the tenant than to continue on with the wage garnishment. Because with the wage garnishment, they can file something called a claim of exemption, where they'll go into court and cry that they're not earning enough money based on their expenses. And it's possible that even with a valid judgment, the judge could say that you're not entitled to collect on your judgment. I mean, don't forget, we are in the state of California and it's not landlord friendly. So we do believe that when the tenant does reach out to us, we do try to do a settlement on that. The last thing is on these cases where you do have a judgment, the process of really turning that judgment into money really is a difficult process in terms of even getting the proper paperwork, like a writ of execution, and what paperwork yet you do have to serve on the sheriff's office. There's a myriad of sheriff instructions, but also the issue is dealing with how to locate the tenant's assets. So on that basis, generally, if you do have a judgment, you do probably want to engage the services of a collection agency that will assist you in collection. Most collection agencies, such as myself, do work on a contingency fee basis so that you don't have to pay if we don't collect. And if we do collect, our contingency rate on standard judgments is 50%. But I'll tell you, my friends, 50% is better than nothing. And for those people that do have judgments, maybe you obtained it with my firm but didn't have us do the collection, or possibly you have obtained a judgment in a small claims court or from another attorney. If you did want to use our collection agency, it's so simple. What you got to do is go to my website, evict123.com. That's EVICT123.com. And then up on the top, you'll see start a collection case. Hit that button, you upload the judgment, and we're off to the races in terms of collection. And with that, members of the Apartment Owners Association concludes my topic on collecting against your deadbeat tenant. So now, Jeff, if you want to open it up to questions, I'm ready.
Great. Yeah, let's open it up and see if you're in the Zoom meeting, please go ahead and raise your hand. I see the chat. There's a question there in the chat, and we definitely have some questions on YouTube. And so great stuff. Thank you so much for sharing, Dennis. And yeah, let me see. This one's not related, but I know you'll be able to answer it. Can you give a 30-day notice to vacate an RSO property that you rented for 9 months and you don't want to renew the lease?
Under RSO property, once you rent it to them, you need good cause to evict. If your property is under the just cause ordinance, that is those properties that were built after October 1st, 1978, then if the tenant's there less than 6 months for RSO, then you can ask the tenants to move. So if you have JCO properties, my recommendation is just do month to month. This way, in the fourth month, if you don't like this tenant, but he's not enough to really start an eviction, all we would have to do is serve a 30-day notice to vacate.
Great. All right. And this one's not related, but I did talk about it. We talked about that civil and criminal investigative search. And so the question here from Sharon is, does AOA offer that? And so of course we do. And I don't know of another company that does it. You would literally have to go directly to a private investigator to get the same service, and they're probably going to bill you about $85 to $100, potentially more for that. Ours, it's $28, and so it's quite a bargain on that, and an ounce of prevention, right? Sure beats a pound of cure. And yeah, so you can sign up for that pretty easily, go into your AOA account and get the tenant screening activated. And there's a couple different options there. If you don't need the credit report, if you just need that, you can sign up for just criminal and eviction reports, and it would be included there. And if you want all of it, then you can do that as well. And anyway, so great question. And yeah, I mean, I talk to people and they say, yeah, I ran the 3-star, only had the eviction and the credit report, and then we got such a bad renter. You guys' report's not any good. It's like, well, you have to run the right report to get the right information. And so please don't run just a 3-star. Spend a little extra money and make sure you get the right person in there. All right. Okay, the next one. Can you record past due rent on a tenant's credit? And so this question, I'll take this one just because it's not debt collection, it's really rent reporting. And so AOA does offer rent reporting. There's a new California law, and basically you have to offer a positive rent reporting. However, the way that the law is set up right now, if they are Section 8 or some kind of on some kind of government assistance program, then you would be able to offer the full rent reporting, meaning both positive and negative. But lots of times what happens is that everything starts off good. So offering the rent reporting, it helps keep things good. You're rewarding your good renters for paying the rent on time, and they're prioritizing paying the rent because they know it's building their credit. So, so it's kind of a yes or no. In most cases, you're just going to only be able to report positive. But the thing is, it's positive up until it stops. And so actually, when you're looking at a credit report, look for that kind of a trade line where the rent reporting, where it's rent reporting and see, did it stop um, as, before they, like recently, did it just mysteriously stop or not? All right. Okay, let's see. Next question. Let me look here real quick. I want to make sure.
While you're looking, I just want to let you know on that positive rent reporting, it really only applies to buildings that have 16 units or more. I guess you could do
Right,
offer it to your tenants for less, but but you're mandatory units.
right. Absolutely. Thank you for adding that. So, and people ask that question, is it the portfolio of 16 units? No, it's a building. You have to have a building that's 16 units or more. If you have 50 units, but you don't have a 16 unit building, forget it. You don't have to do it. It's just a way to reward good renters to help them build their credit. And also it's kind of, it helps you. It does bring some accountability. All right, next question. Can the debt be sold to a third party?
You can certainly assign a debt to anybody. Yeah, and if they're willing to pay for it and you feel that's worth, now usually they're going to do it on cents on the dollar. You're lucky if you get 10 cents on the dollar, but yeah, that's a really good one to do.
All right. And why is the city not responsible for this unpaid rent?
Yeah, good question. They're forcing us to take these tenants. They should pay for it, but I guess that's going down a rabbit hole.
Right, kind of is. Okay, does filing an eviction go on a public record?
Now, that's a great question because this is one of the worst pieces of legislation that the California legislature did. And that is that when you file an eviction, it is masked, it is sealed, no one can see it. If you obtain a judgment, allegedly within the first 60 days, then that judgment would be able to be reported. And when, for example, the AOA is doing their credit eviction check, you would see that. But if the tenant files a bunch of delay tactics and you obtain a judgment, a valid judgment, but it took more than 60 days, incredulously, the way the law states is that the record is sealed so that nobody knows that this tenant was evicted, even though the tenant was even more gruesome than the tenant who you got a judgment on within the 60 days.
Yeah, I really believe that our civil and criminal investigative, I think it gets around that because it's a private investigator that's going. And but I have to check with them, but I believe they get around it.
I don't think they can see eviction records because those are sealed. In fact, in certain cases, they wouldn't even let us look at a record, even though it's our case.
Okay.
So
All right.
it's crazy.
Yeah, I know they report evictions on that, so they're just reporting the ones that are not sealed, I guess.
Right.
Yeah. All right, and let's see. Okay, let me see. Next question. Rent increase of 2.7% is for the city of LA only.
And the answer to that is yes. The city of LA, and it's not law yet, but it will be law shortly,
Right.
will be, again, the rate that they're now going to allow you to increase your rent is 90% of the CPI. This year, the CPI is 3%. So it's going to be 2.7% rent increase. And this is on the face of so much escalation of costs to run your building. Certainly with regard to insurance, which is going through the roof if you're not being canceled and then you're scrambling. So this is just an insane law by our city council, and you properly identified them that so many on the city council are democratic socialists, and this is what obviously is happening in New York and Seattle and soon to be Los Angeles.
Right. And that word, it's like it's not Democrat. It's Democrats are not Democrat socialists. These are two, it's totally, totally different. And I think
So,
everybody sees the difference there.
so let
Um,
me ask you, Jeff, do you think we have to be, based on what I'm seeing out there, do we have to be thankful for Karen Bass?
oh gosh, that's like what am I supposed to say to that? I don't know. I think try to find good things to be thankful for in other ways, but I don't know how thankful I am for her if she passes this thing that's going to come across her desk that's going to just destroy housing.
Yes.
All right, let me see here. What's the maximum allowable rent? Okay, so with that, it's LA City, but it's RSO units. So that's units that are under rent control, right, Dennis?
That's RSO units only, not under
Right.
JCO. And regardless where you are in the state of California, and regardless of what you have in your rental agreement or not, you are free to raise your rent to market value if you have a single family home, a townhouse, or a condominium. If you have one of those, doesn't matter what jurisdiction you're in, you can raise it to market level.
Yeah. So someone was asking what is RSO? That's rent stabilization ordinance, and that's specific.
Yes.
When we refer to that, or Dennis refers to that, it's specifically
Yeah, it's
LA
multiple.
City. Yeah.
Yeah, it's LA City, and it's defined as more than one unit where the units were built prior to October 1st, 1978. Now, you could have a condominium that was built before October 1st, 1978, and that condo would be under the rent stabilization ordinance. You have to register your unit, you need good cause to evict, but you're not subject to rent limitations.
All right. Okay. Can anyone request collection assistance? So if they weren't your client, can they go to you to get help
Yeah,
with the
absolutely. As I said, if you go to my website, evict123.com, you'll see up on top there's a button that says Start a Collection Case. And you can just upload your notice, or you can just call our office, which you know the number 1-800-77-EVICT.
And AOA does also offer this. There's a collection agency that's national, and so we are working with them. So it's debt reporting, but it's the debt collection, it's the full thing. They do not need a judgment, but it helps if you have one, if you really want to get it collected. If you don't have a judgment, you could at least get it reported through them, and you might be able to get a collection. But anyway, the way that works, it's the same 50-50 deal. We charge $1 just to process it and get the information to them. We're playing a middleman position because the only clients they take are those with over 500 units. But that's their bread and butter. It's all they do, and is rent debt. So that's all that they do. We found them. They're doing a decent job. I think if Dennis Block does a great job, so use his service just as much. Because we're an affiliate, we do get a 5% um, payout of their 50% portion. So AOA does get a little benefit from it. But anyway, so there's a couple, but no matter what you do, do it. Do it. And probably the eviction attorney that you used, they will also provide the same service. So there's multiple sources on it. But I think that Dennis's office does a great job from just talking to him and hearing what they're doing. I think they're doing a great job with it. So you could give them a shot. Okay, how much do you charge to do a collection? And so you said 50%.
Yeah, the standard fee is 50%. I mean, obviously, if you have a very large judgment, we'll adjust that. And there's the cost of trying to collect
Right.
it can be sizable in terms of we get charged for data searches, what we get charged for getting a writ issued, what the sheriff charges. And these are all costs. And sometimes we'll run a writ on a bank account and it's a valid bank account and there's 3 cents in the bank account. So, but again, this is not going to ever be borne by the judgment holder. We only get paid if we collect.
Yeah, so set your expectation low, but yeah, there's there's court costs and things like that. Okay, I already gave a 60-day notice. Shirley here, I already gave a 60-day notice to move out on 12/31/2025 for a house in Garden Grove. Tenant did not pay his November rent. Should I run their credit report now to have their updated asset information?
You can't run a credit report unless you have a judgment, unless they specifically give you authorization. They might have given you authorization to run a credit report when they moved in, but that's only for that single event. So if
Right.
you ran a credit report, you'd be in violation of the Fair Debt Collection Practice Act. So once we have a judgment, then that's a different story. Then, of course, we can run that to find assets.
Right. And so you mentioned the Fair Credit Reporting Act, FCRA. Another thing that I'm running into a lot, and I'm about to write an article about it, is just people not giving the disclosure of what their rights are as a consumer. So whenever you do run a credit report, you are obligated to give them a disclosure that says these are your rights as a consumer. And that's a federal law, F as in federal, FCRA, but then there's also one for the state of California. So both of these laws overlap. And now you by California law, one California law says you need to give it within 7 days. In certain instances in California, you need to give them their credit report within 3 days. So best practice, end of the day, is whenever you get the credit report, you need to immediately give it to them even before you make a decision. You're not giving it to them only when you're um, denying them. You give it to them every single time, no matter what the outcome is. And anyway, so keep yourself out of out of the risk on that. There's the rental application form that we have, but also there's the disclosures. We combine both the California on the front part and then the back part of that form is the federal. And it's so important that you're doing that on every single applicant that you screen. Okay, couple more questions. You got a couple minutes?
2 minutes, my friend.
Okay, let's make it quick. On a new tenant, can I ask them to pay a percentage of the general DWP bill on an RSO City of LA unit?
Well, if the unit is individually metered, of course you can. If it's not, then you would have to have some way of determining how much water and or electricity the tenant is using. There's something called RUBS, which is the ratio of utility billing system that will install things to determine what the amount of the electricity and or water that they're using. And then as long as you're initiating a tenancy and in that rental agreement, you're explaining to the tenant that you're going to be responsible for that amount, then you're fine to do it.
Right. And so if you go to the AOA website, there's the member benefits. If you scroll down there, you'll see Rubs and a link to it. And we have an affiliate relationship with Livable, and that's something that can be done through there. It takes some work. You have to feed it information, but then it will generate the amount that each of those units would owe. And but that has to be done on the start of the lease and certain areas like Santa Clara County, they don't allow it. So just depending on where you're at with that one. Okay, very last question. Oh, hold on. You know what? I should see. Oh, I got other questions here. This one was blocked. Last one. Uh, okay, can you evict the two new tenants if they don't want to fill out a rental application?
Okay, I think you missed the first part of that question where you had 4 tenants in a unit, 2 of them
Oh,
left.
okay, here we go. Yeah.
And then you want to know if can you ask them that for the new tenants not to move in or to evict them if they fail to fill out an application? The answer to that is yeah. You have to allow replacement tenants under, at least under RSO. Did they stay which place? Yeah, this
Yeah,
is
RSO. Yeah,
so you do have to allow for replacement tenants, but you get to screen them. And if they refuse to fill out an application, then you can say, then I'm not letting you in, and that would be grounds for eviction of everyone from the unit.
right, right. All right, and when you're raising those rents, we did a video. So on YouTube, AOA USA, go to our channel, and Dennis Block has done a video for us, and others too, I think. But there's information on that. You can go to our website as well and put maximum allowable rent increase, and there's definitely a process to doing it. So make sure you do it right. Dennis,
And
thank you so much.
one more thing I wanted to say is don't forget that every Saturday at 3 p.m. I do a Zoom/live YouTube meeting. It is Saturday at 3 p.m. You can watch the previous shows by going to my website, and that's how you get the credentials to join. And that website again is evict123.com. I'm talking tomorrow.
All right. Thanks, everybody. Take care.